Hi, this is Jeff Fowler with the Apartment Owners Association. It's great to have you with us. And in San Francisco, there's some big news with the 10-day notice being preempted by state law, that judgment coming out, that ruling coming out of the court. And it left a lot of questions for everybody. So when do you use the 10-day notice? We all know that you don't have to use it for non-payment of rent. And so we wanted to bring on Rich Beckman to share a little bit, give us some background, and show us how to use that 10-day notice and when we don't have to. And anyway, so thank you, Rich, for sharing. He does the legal Q&A for the AOA magazine in Northern California. And so he's always putting together a great article. I highly suggest reading it and read back. You can even read back a few months and it's all probably still valid. And anyway, Rich, thank you so much for joining us, and please share with us about this ruling that just came out.
Sure. Thanks, Jeff. I appreciate the introduction. Yes, my name is Richard Beckman, and I do write the Northern California AOA magazine Q&A column, which is a pleasure. I actually learn stuff myself sometimes because, I get questions that I can't actually answer right away. So I have to do a little research. And those of you who've written in are probably familiar with that response sometimes. But so as to this development, what Jeff was referring to, in March of this year, the San Francisco Board of Legislatures amended the San Francisco Rent Stabilization and Arbitration Ordinance, which we use as shorthand and call the Rent Ordinance, to add something that Oakland, for example, has had for many, many years. And it's what we call a pre-notice notice. When this came out in Oakland, there was quite a bit of consternation about it. It was challenged in court. And that case went to an appellate level, and a case called Kim versus City of Oakland. The court ruled that basically it's okay to do that, for a city to institute a pre-notice notice requirement. And I was explaining to Jeff a little bit. This is a really interesting area of law because there's a thing called preemption, which is a state law that, as they say, fills the field of any particular area of endeavor, preempts local ordinances trying to affect that field of endeavor. In this case, the field of endeavor is the unlawful detainer process, the statutory procedure by which an owner is allowed to sue a tenant in court under what's called the unlawful detainer cause of action and seek to recover possession or money or both in some cases. And that's a very strictly statutorily controlled procedure. So there's this legal distinction called a substantive change to the state law versus a procedural change to the state law. The state does not allow procedural challenges to its overriding state law. In this case, the unlawful detainer statute of CCP, Code of Civil Procedure 1161, for those of you keeping score at home. But it does allow substantive changes, which took the form of just cause protections. And that started in Berkeley in 1979. It was challenged all the way up to the U.S. Supreme Court in a case called Birkenfeld versus City of Berkeley. So the U.S. Supreme Court has looked at this very carefully. And for those of you who are really interested, you should read that decision because it is the guiding light for this area. But it's a complicated analysis, and courts come down on different sides of it, depending on how it's briefed and the specific issue. In this case, the 10-day pre-notice notice ordinance that was supposed to take effect in March was challenged by some property owners consortium. And it was initially put on hold by the San Francisco Superior Court judge, who issued a stay in May saying, let me have both sides brief this. I'm going to hold this thing so it's not enforceable for now. So that decision that was just issued about a week and a half ago, where the judge did a complete ruling on the entire case issue. And the essence of it is that the 10-day notice, pre-notice notice, is valid. It's a valid use of what's called the police power of the city to affect its population's rights and remedies, except as to the non-payment of rent cause or just cause ground. So as you probably know, under almost every rent and eviction control ordinance, there are a number of what are called just cause grounds that allow an owner to proceed against a tenant. And from non-payment of rent through breach of the lease, being a nuisance, those are the main ones, basically. And sometimes they're in the lease. Sometimes it's just a matter of state law that applies whether you have the provision in your lease or not. So previously, just a 3-day, there's a under Code of Civil Procedure 1161, there are 3 categories of 3-day notices. The first one is for non-payment of rent. The second one are for curable breaches, like having a pet, having a having a water bed when you're not supposed to. I mean, things that the tenant can cure. And then there's a third category, which consists of nuisance and, surprisingly, subletting without approval. I've always found that a little bit odd, where the owner has the right to deem that a non-curable breach. Like if you commit a nuisance, legal nuisance, like, you've torn up the place, you've threatened neighbors, you've just disrupted their life, the landlord does not have to give an opportunity to cure. And similarly, with an assignment or a sublet without permission, you can just serve a 3-day notice to quit. No cure allowed. Now, those have been affected by local ordinances that remove that right. And again, this is where the legal analysis between procedural and substantive changes just gets really tricky. And again, it's just a judge can find, I think, a different ruling in practically every case. But in this case, the challenge was successful as to the non-payment of rent cause of action, meaning you do not need the 10-day notice for non-payment of rent cases. For every other just cause ground under the San Francisco rent ordinance, you have to, before you can serve a 3-day notice, you have to serve a 10-day notice. Now, the San Francisco Rent Board has prepared a form. So, and whenever the governing rent boards prepare a form, use the form, because you can't go wrong. I mean, it probably goes without saying, but yes, if they have a form, I would not ever not use it. I just can't think of any reason not to. And so you can find that on the San Francisco Rent Board's website, which I must say is a good website. It's got a lot of, easy to find information, help topics, what's new, so to check in on that every so often, if you have San Francisco property, is just basic homework. So if you go to that website, they'll have the form. I'm going to guess AOA may duplicate it. It's not a proprietary form. I mean, it's not copyrighted. So, make it easy if you want. Note to Jeff, I'll leave it at that.
Oh, no, yes, we do. That form is on the website. It's exactly that form. And so, we've no alterations to it. We want to make sure that it works for every. Yeah.
So, it should be pretty self-explanatory. But you give that notice. Now, one question, I guess, that's going to have to get decided, because I didn't see this in the ordinance, is how do you serve that notice? Because 3-day notices have to be served very specifically according to statute. And the statute says you either first try to hand deliver it, and if there's nobody there, if the tenant's not there and somebody else is there, you can sub-serve it, meaning you hand it to that person, and then you mail a copy to the named tenant. And if no one's there, you post and mail it, meaning you post a notice on the door and you mail a copy. There is no discussion in this particular ordinance. Let me just look at that real fast. I'm going to bring up my little cheat sheet. So bear with me one second. So the grounds for recovering possession set forth in all of these just cause grounds shall not apply unless the violation is not cured within 10 days after the landlord has provided the tenant a written warning that describes the violation and informs the tenant that a failure to correct within 10 days may result in eviction proceedings. The rent board shall prepare a form that landlords may use for this purpose. However, it shall not apply if a longer notice and cure period applies. And this they're referring to whether it's in your lease or rent payments that were due between September of 2020 and March 31st of 2022, because the state required 15-day notice. But so they said this doesn't apply there because you already have a 15-day notice. Or if the landlord is seeking to recover possession because the tenant is causing or creating an imminent risk of physical harm. So you still get to do a 3-day notice if it's a true nuisance, like a physical, like somebody's threatening the other tenants. So, and thanks, that they made that one, an exception. But the court just ruled that basically it's okay to require this additional 10-day notice for any eviction basis other than non-payment of rent. So that's really the long and the short of it. If it's a non-payment of rent claim, you don't need a 10-day notice, just your regular 3-day notice, modified, as the rent board previously requires, with a little notice to the tenant about some different things. And a 10-day notice for everything else, except for a violent, or a truly imminent risk of physical harm to the person or property tenant. And what I was sort of asking myself was, well, how's the thing supposed to be served? Because, if you serve a notice a certain way, sometimes you add 5 days to it, like a notice of termination. If you mail it, you add 5 days. If you hand serve it, it's the original amount of time. So this doesn't really address that. So that's going to be a question. If you mail this to the tenant, and I'm going to guess this probably, I'm going to say for my clients, I'm going to have this served just like a 3-day notice, which is a process server. And that's going to add a little cost, because each time the process server goes out there, it's $100, something like that. But I think you'll eliminate challenges, because otherwise there's almost certainly going to be a challenge if it's just mailed to the tenant or emailed to the tenant. So I just try to avoid those challenges, because if your notice is, if you end up going to the unlawful detainer case, your notice is the foundation for everything. If the notice is either defective in form or in service, your whole case falls apart and you start all over. And so anything you can do to eliminate that risk is to your benefit, even if it costs a little, upfront, because it's really annoying to be told at a hearing on a demurrer that your complaint is going to be dismissed because your notice was defective, either in form, because it didn't include required language, or because it was served improperly, because you can't cure that. I mean, you have to dismiss and start all over. So yeah, I would say I would do my 10-day notices just like a 3-day notice. Just hire the process server, or you don't have to hire a process server. Property owners can serve these notices as long as they serve them correctly. So maybe there should be a little seminar on that one of these days.
Great. Hey, Richard, thank you so much. Yeah, I think that really covers it. So there's those two reasons for non-payment of rent or imminent physical danger. Those are the two times when you don't need to serve it. The rest of the time, serve
In a
it.
nutshell.
And to cover all your bases, just serve it like you would a 3-day, and just keep to be conservative.
Yeah.
And well, great. Thank you so much for just bringing a little light to it.
Sure.
And we really appreciate you. And looking forward to reading next month's Q&A.
I'll be sure to send you a postcard from Turkey.
All right. Sounds good.
All right. Take it easy, Jeff.